Hello and welcome. In this video, we're going to discuss the initial notice phase of a personal injury case. So let's get right into it. At the beginning of a case, we need to send out an initial set of documents to inform the other side that you are represented by counsel. Typically, we will send out two main types of documents: a letter of representation and a request for insurance information. In some cases, we may also send out a letter of preservation, which we sometimes call a spoliation letter. Once we receive an acknowledgement of the notice and the insurance information, we can move on to the next steps in the process. Now, let's talk about the letter of representation. The letter of representation lets the other side know that you're represented by an attorney, and it puts them on notice of your injury claim. The goal is to get a point of contact on the other side that has the authority to resolve the case. Typically, this person is an insurance adjuster, but it could be a defense attorney, depending on the case. The letter of representation will typically include basic information that will help the other side understand what the case is about. Some of this information could include your name, how you were injured, when you were injured, and where you were injured. And if we have the insurance information, we might include things like the name of the insured person and the claim number. Now, let's talk about the request for insurance information. This letter is typically either sent to the person who is potentially liable, or it may be sent directly to the insurance company, depending on what information we have at the time we're sending out the letters. The request for insurance information allows us to determine if there's insurance and how much coverage is available to pay the claim. Typically, insurance companies must respond within 30 days of the request. When they respond, they'll typically provide us with the coverage information we need, like the name of the people or entities insured under the policy, and the limits of liability coverage or the total amount of coverage available. Once we have the insurance coverage information, we can better assess the case and work to develop the appropriate strategy moving forward. Now, let's finish up by talking about spoliation letters. A spoliation letter essentially tells the other side not to destroy or lose any evidence that may be important to the case. This could include any evidence that might be relevant, like video footage, photographs, emails, important documents, or a vehicle that we need to inspect. If the other side receives a spoliation letter and then loses or destroys relevant evidence, this loss of evidence or spoliation could be used against them later on in the case. Not every case is going to require a spoliation letter. However, when there's a risk that important evidence could be lost or destroyed, a spoliation letter can be a helpful tool, especially if the case goes into litigation later on. So, how long will this process usually take? Generally, we send out our initial packet of documents as soon as possible after a person signs with us and becomes a client. Then, once we send out the initial packet, the other side will usually receive it within a week. After that, we will typically receive a response within 30 to 45 days. Well, that's the initial notice phase of a personal injury case, and that's all I have for you in this video. If you have any questions about anything, please don't hesitate to reach out to us at 321-LAWSUIT. That's 321-529-7848. Thank you so much for watching, and we'll see you in the next video.